Jeffrey Foss.
Here.
Leonard Knapp.
Here.
Harold Parikh Sr.
Here.
Eula Simeon.
Present.
Lenore Feeney. Here. And Jason Hamlin.
Here.
And just for information purposes, we received a text communication from Jared Rickey this morning, who was on his way here, but apparently I-12 is a parking lot somewhere around Hammond right now. So I don't think he will make it this morning. Just ask for a moment of silence. And pledge of allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this point, we have on the agenda an opportunity to address the commission by employees or others. We did have one request from Mr. Miet, but after discussion, because of the manner in which this meeting will progress, because we're going to allow discussion as we get to the items that we are proposing changes to in the rules, Mr. Miet has withdrawn that request, reserving his right to make some comments when we get to a specific item or items. The next item on the agenda is the business of the meeting and its consideration of the November 8th, 2018 minutes. Entertain a motion.
Second.
So motion to approve the minutes from November 8th, 2018. All in favor?
Aye.
Any opposed? The ayes have it. Next item on the agenda is an open discussion of the working papers relating to revisions through chapters 13 and 16 of the State Police Commission rules. The reason we put this on the agenda for today, we are in the process of trying to go through chapters of our rules and make amendments, and we want to keep this as open of a process and transparent of a process as possible. We previously had issued a circular, and we got some comments on that circular. And the circular simply announced that it wasn't a circular, it was an announcement that we were going to be considering changes to the rules. We got some comments on those. And so now, rather than simply promulgating an announcement of a proposed change, we're going to have basically a working meeting and open discussion as we go through. What I propose we do in order to do that is, as you can tell, we have it projected up on the screen there, and what we'll do is we'll pause at the various sections that we are proposing making changes to. The way it works, if you look on the left side, is what was promulgated pursuant to 195 as to what we were thinking about at the time. Right next to that, on the right side, are the additional changes we are proposing to, we're not going to vote on this today, but that we are proposing will be what will come up for a vote probably in the January meeting, with the changes that we've made in response to some of the comments that we got. But we want to open up for further discussion if there's a need for further discussion. And we'll just take those sections where there are proposed changes. If there's a section where there was not a proposed change by us, but someone thinks there needs to be, then they can bring that up as we get to that particular section. So the first part of Chapter 13 that we are looking at changes to is Chapter 13.1. You will note, and it's not scrolled down yet, and we'll get to this in just a second, but you will note that there are multiple subsections under Chapter 13.1 that we are proposing to delete. It is not intended by the deletion of those additional subsections to eliminate those rights, but we believe that those claims can legitimately be brought under either A, B, or C, as it currently exists, so there's no need to specify all of the things that are currently specified under the rules. Was kind of the thought process on the elimination, to simplify the rules, because we believe that all the things that are covered under D through M are subsumed within A through C, rather than specifying all of those things. Now, if you take a look, if you scroll back one page, Jason, you take a look at what our current thoughts are on where we're headed with this. In the right-hand side, you'll see we have the same thing we promulgated in 195, except what you see highlighted in the yellow highlight is what was added based on the comments that we received. Anyone have any further comments on that particular proposed change?
Which one?
Well, whatever is let's start with A. You got that?
Well, let me, Floyd Falcon, on behalf of the Troopers Association. Jason just handed me this 61 pages about 3 minutes ago. Haven't looked at it yet. And I made a substantial number of comments. What I envisioned is that we would have an opportunity to look at what revisions y'all made as a result of the comments you received from whomever, or comments that y'all generated yourself, and we would have an opportunity to comment on that. So I want to make sure that this is not the public hearing for purposes of receiving comments on the rules once they finally propose. I think we have to get to the final, y'all final proposal before we have the public hearing.
And no one disagrees with that.
I just want to make it clear.
And our whole idea is not to say that this is the public hearing. This is not the, well, this is obviously a public meeting, but it's not the public hearing. You will have an opportunity at the appropriate time to make whatever additional comments you want to make. Our idea is we're trying to streamline the process and give everybody an opportunity.
And we want to cooperate. I don't want to sound like an obstructionist, because some of the rules I fully agree with, but some of them, I had some issues with.
I will tell you this, both I and Jason looked at the comments, and actually Commissioner Knapp also gave some input on your comments as well as other comments that we received, and we did try to address those. But certainly, no one is going to be prejudiced by what happens today. It's more just an opportunity to discuss more. And if you have any of your particular comments from what you had sent us that you want to raise at this point, and we can have a discussion of that, we certainly can.
Our review goes online. They were on the commission's website, or were there some corrections to that?
The General Circular 195 was published online on the commission website. These revisions since that promulgation is what we're reviewing today. So the right-hand column is the revisions, the edits to those initial proposed changes. And so I emailed a copy to council yesterday, but it might have been late in the day. But this is just to facilitate the conversation. It's not to the final vote or anything on this matter.
So, and that's just me, what I was referring to. What was online is on the left-hand side. Any changes to what was online is on the right-hand side, and you will see the change because it's highlighted in yellow.
Okay.
There's been some.
Assuming I can see that far.
There's an additional copy there on there.
I can get you a front row seat right there.
So, Mr. Falcon or anyone else, is there any, you want to reiterate some of the comments you previously made in writing, raise those up at this point?
Maybe so. And what I would do, Mr. Chairman, is just really kind of hit the highlights.
Oh, yeah, let's not.
one of the ones, what, the first one that grabbed me, you know, this is a general conversation, I'm not suggesting a particular change or anything like that, but just some general comments, that's what I understood we were going to
Yeah, yeah.
So, the idea that y'all would have the state police do investigations for y'all blows me away. I mean, vis-a-vis where I sit, the Office of State Police is often the adversary. So if we're gonna have the Office of State Police doing, and they're the other party in the case, and y'all the judge, you see?
Can I hold you up for just a second? We've already fixed that issue.
Well, I would hope so.
But perhaps in Rule 13.1, the one that's on, right now you've had some comments related to the removal of D through M. Start with.
Yeah, that's what you had previously commented on, the removal of those. And going into it, I expressed what our thoughts were, is that
Right.
that removal is not intended to eliminate those things. We just think they're covered.
Okay. The second one that was pretty egregious to me was I think it was 13.1L. Let me just look and see. I don't have them in that order. I wasn't.
The other one dealing with applicants for employment.
Yeah, it looks like to me y'all trying to prohibit an applicant from having any access to this commission. And I don't know where else they go if they don't have access to this commission.
We're limited by the Constitution and what our authority is, and our authority under the Constitution does not extend to applicants. I think they would go to the court system is where they would go. That's I mean, if you've got some different thoughts on it, you're welcome to present them, but that's why we eliminated that. I should have made that statement, because I said it's all covered through A through C, but yes, on the applicant issue, that is a substantive issue that is not covered in A through C, but it is our view that based on the Constitution and enabling statutes that set up this commission, we do not have authority to deal with that.
General comment, I think that your description of discrimination in the definition section is adverse to the description that y'all propose to use in chapter 13. The definition of discrimination in chapter 1, the consideration of appointment removal. So it seems to me that appointment would include applicants.
Well, we haven't, we didn't take them in numerical order. We didn't start with chapter 1.
Right.
But that's an issue when we get to chapter 1 we would have to address.
All right. It also talks about discrimination. Chapter 1 also talks about probationary employees, you see. So,
I understand.
and so it looks like to me that y'all further limiting the rights of probationary employees to come to this commission if they're not treated properly. So that's something y'all should consider. Maybe you are considering it. Like I said, I hadn't had a chance to look at that yet. Now,
Just in brief response, since I know you haven't had a chance, we have certainly considered the comment. At this point, I think there's a disagreement over what the authority of this commission is, and we will relook at that issue. We'll research it some more, but our current thought is that based on the Constitution and the statutory enabling statutory provisions, that would extend beyond our authority. We'll relook at it.
I was concerned in 13.1K that you're limiting the rights of an employee to appeal that he was disciplined solely on the grounds of having received an unsatisfactory service rating. I gotta tell you, I never saw that being used as a grounds to terminate somebody. But if it was used as a grounds to terminate somebody, the unsatisfactory service rating, you can challenge through the process in the rules, but the state doesn't have the burden, the state police doesn't have the burden of proof in that proceeding, whereas in a disciplinary action, the state police would have the burden of proof. I believe that's a serious issue.
You want to respond to that?
And I would just state that in my research on the Chapter 10 rules, the performance review rules, there was a general circular passed in 2011 that removed the appeal right for a performance review. So it was determined it was not within the appellate jurisdiction of the commission to review a employee's performance rating. And then subsequently, Chapter 10 was replaced in its entirety in 2013, I believe it was 2013. And the appeal right was not reflected in Chapter 10 at that point. So the cleanup in this chapter reflects something that had already been removed from Chapter 10 previously. And additionally, the 3.1K, the term unsatisfactory is no longer a performance rating. It needs improvement.
Well, I think you said, you're working on other rules, but those rules are still in effect, so right now.
Well,
I'm concerned about burden of proof. That's the whole theory. As long as you'll understand, I'm concerned about burden of proof. If I want to challenge, if I'm going to be disciplined or demoted or whatever, I want the state to retain the burden of proof on that.
but that, in our thought, Mr. Fowler, that's a different issue. We do not exercise appellate jurisdiction or review jurisdiction over the rating of unsatisfactory. But if there is an action over which we do have review power, and that is brought, then the state police is going to have the same burden that they would normally have to prove that the action that is subject to our review, that they have met the burden of proving that they were justified in those actions.
Another problem I had is in my comment number 6 about 13.1L. The Constitution provides that there should not be any discrimination of an applicant or an employee, because of a membership or non-membership in the private organization. You delete that. I understand what you're saying. You're trying to simplify, and maybe you believe, but look at it from the standpoint of the employee. Look at it from the standpoint of the young trooper. They get a copy of the rules, and you had your rules, and this sets forth all the things that you can appeal. Y'all deleting that now and making it, in Globo, it is making it less clear, I believe, to an applicant. I don't know if it's going to affect me and my thoughts about what I can come to y'all for, but I'm talking about the knowledge of an individual trooper by taking away the examples. I looked at, those letter numbers as sort of being examples of the kind of appeal you can bring to this board. And I thought that was helpful to a uninformed public servant. I would guess if we had a test of all of the troopers that graduated from the academy, none of them would know that there's a prohibition against discrimination because of your membership or non-membership in a particular organization. I mean, if we had a test, my guess would be 10% or so might understand that, the others might not. So one of the things about delineating these, and I understand what you're saying, Mr. Chairman, about those enumerations were sort of included in ABC. I get that, but they certainly were helpful in an individual looking at the kind of relief they can seek from the commission. Comment.
All right, thank you. Well, and we're not voting on it today. This is not the final. We have considered those things, and we certainly will further consider them as we move forward.
You know, and is it your intention that no probationary employee would have an appeal to this commission under any circumstance? Is that what we're talking about?
Just one second.
I think it's still preserved for discrimination, right?
How about violation of the rules?
That's,
Let me tell you why it comes to my mind. I have appeal pending in the state civil service today. Not today, but I mean pending right now. And it's a probationary employee, and there's a rule that says you gotta, the director, if you satisfactory, not the director, the appointing authority, if you satisfactorily complete up to two years of probationary service, that they have to notify the director that you've been made permanent, okay? This fellow's he's actually a police officer at the Baton Rouge Community College, which comes under the State Civil Service Commission. And he was promoted, he was hired as an officer, served 3 or 6 months, something like 4, 5, 6 months. Then they made him a sergeant. Must have been doing better. They made him a sergeant. He served 25 months as a sergeant. 2 days before they fired him, they gave him excellent service ratings. Then they fired him for no reason and said he could not appeal because he wasn't made permanent at the end of 24 months. Well, if you perform satisfactorily, they have to make you permanent. And I'm having grief over that right now, but I think if we just look at he's a probationary employee, so we don't care about it, we're not going to hear him, that concerns me.
Well, it's not, obviously not an issue.
It's not a discrimination case, you see. It's a rule violation. It's not a discrimination, but the appointing authority, if somebody performs during their probationary period in a satisfactory manner, they should get made permanent. And if you don't get made permanent, you sure ought to be able to have an opportunity to address that issue.
and Mr. Chairman, if I may, and that's actually addressed, well, partly addressed in Chapter 9.1C. I believe it's the same as state civil service, in that a probationary employee may be removed by the appointing authority at any time. And then,
Yeah, my point is, after 24 months, he's not probation. He's either fired or probation or made permanent. And then the 24 months expired and nothing happened. It's not his fault.
We have a similar.
I would just say, in my prior experience under state civil service, in a similar instance where an employee believed that they were permanent after the 24 months had passed, it was my understanding from having a conversation with civil service that there had to be an action taken by the appointing authority. But if an action was not taken by the appointing authority, it didn't automatically bestow permanent status.
I agree.
And so
It doesn't automatically, but if you limit it to 24 months, how do you fire him after the 24 months? What made this case, the particular case I'm talking to you about, relevant or really to the point, is the guy got the service rating. He got his service rating at the same time, saying he was great.
Well, let me just get a clarification from the director. Do we have a similar rule on 24 months or 18 months or 85 years in our rules?
we have, in the probationary period rules, it does state the probationary period for all employees shall be 12 months from the date of graduation from the academy, but it can be extended.
Okay. I'm talking about a provision that says after a certain period of time, they either automatically or have to be appointed. And
Must sign the document once the 24 months expires.
Something should happen at 24 months. And in this case, it didn't, and that's the whole point of my appeal, you see?
Oh, I
And
understand.
so now they sent me yesterday, actually, a
Mr.
rule to
Malcolm,
show cause why he shouldn't be dismissed because there's no jurisdiction over that.
I understand, Mr. Falcon, you're concerned in civil service. I want to see if we have a similar rule here. If we don't have a similar rule, the concern you have in civil service is not relevant. We'll look into
Yeah,
that.
we'll look further into it. I don't see one else.
But we'll certainly look at it and consider that.
13.1M would deny employees the right to appeal from Chapter 17 layoffs.
I believe, Mr. Chairman, that's where Chapter 17 is a chapter in the rules, and if there was a violation of provision of Chapter 17 layoff rules,
It would be covered by
then it would
C.
be covered by A, B, or C.
Yeah, it would be a violation of the rules. Since they're laid off in violation of Chapter 17, they're laid off in violation of the rule, and therefore it would be in violation, it would be covered by C.
And I agree, but it's another example of an enumeration that helps the employee realize or understand what kind of matters they can bring before this commission. I understand it's a violation of the rule. If there's a violation of the rules that you can do that, but I don't understand the need to eliminate the enumeration of the types of things that you can bring before this commission. That's just.
All right, comment well taken.
Now, I gotta tell you, y'all idea about, y'all blew me away with this idea about designation of established facts or admissions. Y'all determined something's admission and we can't put on any evidence against it. Well, so then we have to go to the Court of Appeal.
We fixed that problem by allowing the proffer of evidence. If there's a timely objection, then you could proffer the evidence.
Okay. The motion for summary disposition provision also caused me some problems because it gives an advantage to the state. The state police can order their people to come in and give them a statement, order them to come in and you're gonna have to write a statement about this and presumably would create an affidavit and so forth. I can't order anybody to give me an affidavit, you see. They can say, "To hell with you, Falcon, I'm not gonna talk to you." Happens sometimes. It seems to me that you're limiting or you're creating a situation where there's an advantage to the Office of State Police in that regard. I can't force, in order to defeat a summary disposition, I don't have a right to take somebody's deposition and or force them to give me an affidavit or even give me a statement.
Just 1 second. What number are we talking about? It's the one on summary disposition.
Yeah, it is on summary disposition. I think it's 13.5 G, H, and I is the ones I can.
Right, and why don't you turn to that, because we have substantially revised that in the proposal
Well-
that we've submitted to.
Well, I apologize for not
No,
being
no,
able to
no,
come in, but I just didn't know.
Well, no, and that's why we're here, to talk about that. It no longer tracks the summary judgment language from the Code of Civil Procedure. We had seen your comments on that, and we tried to address those. If it didn't fully address them, we are going to issue this. It's not long after we meet here as an official circular, so that you can then make some additional comments at that time. But we wanted to give people an opportunity.
And I appreciate it because, I mean,
Yeah.
you know, I didn't know, frankly, I thought of a better procedure, and I don't want to use I don't have the authority to give you all any suggestions, but, you know,
That's what we're here for.
it would have been good, I thought, if myself, Michelle, Lenora, maybe the chairman, and the director got together and talked about all of this before it got put in writing, and you know, so but that's just my thoughts on the thing. my little few comments I made, it took me a good while. I mean, this is something I had to think about. It took probably a better part of the day to do that, to think about all of these changes and so forth. And so I just want to make sure that we have the opportunity to do it again, or if there's going to be some more changes after the day before they officially promulgated, just as long as we get them in advance, it's all right. That's okay with me. But I believe it seemed like I glanced at the rule yesterday and said you had to publish it for 15 days before.
Correct, and that's why we're
Before we have a public hearing.
Correct, and this is not a public hearing.
Okay.
And that's why we are meeting, we plan on publishing these later this month, well in advance of the 15 days before the public hearing in January. But we wanted to get input based on where we are so far.
Okay.
And I understand you kind of behind, because you just got the changes we made to what we previously published.
Sure. And listen, I appreciate Jason. Jason called me and told me I wasn't even coming to this meeting today.
You didn't want to come see us?
But, well, I didn't have anything, I had something else to do, but Jason called me and told me that we were gonna have this discussion, so, and I appreciate that. He tries to keep me advised, and it certainly is helpful, I appreciate that. Another thing, did y'all look at 1317 about if somebody refuses to testify that they forfeit their position in the government and so forth?
We did look at that provision.
Suppose they refuse to testify and they take the Fifth Amendment.
You're not asking us legal advice, are you, Mr. Bowman?
I mean, you know, can you hold them in contempt and punish them?
I think there's some pretty well-established Fifth Amendment jurisprudence that we're not going to get into a discussion of today, but the Fifth Amendment jurisprudence would obviously control over anything that we would do. As I like to tell my students when I'm teaching class, the supremacy clause is alive and well because the Northman War. But we did also make some changes to that. You might want to, when you get an opportunity, go back and look at the changes we made to that rule. The proposed change that we had, we made some changes to that, which ameliorates some of your concerns, I believe.
Okay. How about, suppose somebody, what happens? This has always been an interest to me because, you know, we had a recent case where we had somebody who was no longer in the classified service, and everybody, including everybody, I believe, was concerned as to whether they would show up for subpoena and come and testify or not. Do you propose these? Does the commission believe it has contempt power over somebody who's not in the classified service? How does that work?
You're talking about contempt power.
Well, suppose I subpoena a non-employee and they don't show up. What can we do about that?
I think it's the same problem we have in state civil service, because it's not clear there either, whether you just go to the district court and get the court to issue, you know, some.
I'm not aware of anybody ever doing that before.
I know, we always threaten it, but it's never happened that I know of.
It's not, but always it was a concern to me. So while you're adopting rules, why don't we talk about that? Because that's a problem that could come up, you know, in a lot of cases. You know, if the result is to go to the district court, does the commission go to the district court, or does the appellant go to the district court? You know, it would seem to me maybe the commission would go to the district court and ask for enforcement of their subpoena power.
We'll look at that lapse before we issue the proposed change.
Okay.
Or potential lapse.
Sure. Or the mediation business.
One second, Mr.
Is that non-binding?
Just one second.
Oh, I'm sorry.
No, that's okay. Actually, I think the way we're doing this now, letting you go through all your comments rather than us going section by section, is probably a better way than what I originally proposed. And so I would suggest that unless there's objection from the other commissioners, that we just continue it in this process rather than the process I originally set forth. All right, so go ahead then.
Well, you know, it's something about binding. I wanted to know if the mediation, if we're going to have mediation of any type, is it going to be binding, non-binding? How can it possibly be binding?
Mediation, by definition, I don't think it's a binding situation.
Well, if it used the word arbitration, it could be binding.
Well, no, but
Yeah.
I don't, did we use arbitration?
No, you use mediation.
What's that?
Just page 45.
Yeah.
You use mediation.
Right, yeah, so,
And that's, those are old ones.
You know, insertion of the word non-binding would make me happier.
if we make it clearer,
Make me happier.
we certainly can look at it.
Sure.
Insertion of the word non-binding, because mediation is not intended to be binding. That's, but if that makes it clearer, then it's certainly not a problem.
You know, I made a few other comments about it, but I think your comment and your explanation, Mr. Chairman, about your idea in eliminating those, like DE, all those individuals, I just have a different, I mean, I think it's helpful to the employee to have examples of what they can appeal. But if y'all don't think it's necessary, it's not necessary for me. I think that's all the other comments I had. I had one comment, I think, about Michelle's comments.
We'll let her rebut in just a second.
Sure. She was talking about the pretrial discovery. I didn't really particularly understand oh, I know what I wanted to tell you about. I didn't understand the comments about pretrial discovery. I mean, we're still not going to have pretrial discovery of any type, but y'all had proposed, and this is what we've always done. I mean, you know, for instance, in the San Diego case, if we wouldn't have got those documents in advance, you know, the question is you get, so Lenore has always said, and Lenore's younger predecessor, Mr. Norfolk, used to always say, he bite on to that idea that give us the documents in advance, because a few times at this commission and other commission, if they didn't do that, and this is not you poor guys or you 7 guys, but there was a time in the State Police Commission where they wouldn't give it to me until the hearing started, okay? So they'd give me this much documents. And I'd say, okay, I want a 4-hour recess to read all of this. Puts everybody in a bind. What I'd like to do is maybe have a rule that if we exchange documents, why not have a rule we exchange documents 5 days before the hearing or 3 days before the hearing, something like that, because it makes my ability to, or my successor's ability to prepare a lot better.
We'll take a look at that.
But I thought that was a good comment Michelle had, and the other thing is, I didn't understand the comment about notice of the hearing pursuant to email. So does everybody have email? You know, I have email, but sometimes I forget to look at it for a couple of 2 or 3 days, you know, or I don't want to look at it because it gives me, some of it gives me a headache. But I'm old-fashioned, but I like to get that piece of paper in my hand. And I think Michelle's comment was it might cost too much. Tough luck. It only costs 50 cents. But sending somebody emails, I don't know how many of my clients look at their emails every day. They probably do better than I do, but.
Yeah, just say, do you know what rule we're talking
Now, there was a comment that, Mr. Chairman, that was a comment we received from the LSP asking about the possibility of email notifications just to speed up the process. And what we've actually, if you scroll down to page 47, we're looking to include, and at the end of chapter 13, is the option, the ability to opt in. If you would like to receive email notification because you use it and it's more timely for you, you can opt in to receive email notification. And then we also had made, by practice, what we would do is send an email, but then follow up with the hard copy in the mail on notification. But we're looking at
Well,
this.
if you do both, that's perfectly fine with me, but
Yeah.
if we just do email notification, I don't think that's fair.
Yeah, look at page 47, we think we have addressed that.
Okay, one last comment that I had. This is pertinent to me. It had to do with mandatory reasons for a continuance, okay? I have a trial, I think I have a 2-week trial in federal court in February. And I think it happens to fall during the time we have a commission. Well, if somebody wanted to set a hearing on that day and I have a 2-week trial in federal court, I want to be able to know that I'm gonna get a continuance. And I gotta say, nobody ever denied me one before. I don't wanna. But if they got mad at Falcon and denied him a continuance under those circumstances, I mean, what do? I have to go to the Court of Appeal because Judge Dick has me over in federal court, and if I'm not there, she sends the person out to me. So I thought that ought to be a mandatory grounds if there's if a conflicting trial appearance by an attorney would be a mandatory right for continuance. And like I said, it really has never been a problem. Nobody's ever done that to me, but I just have this fear.
You want to rather be safe than sorry.
That's it.
Well, I'd suggest you go see Judge Dick if you get that situation.
Yeah. Right, you won't even get in the courthouse if you went over there to do that.
We did receive your comment, we looked at it, and obviously we haven't voted on it yet. I'll tell you my personal view. I am disinclined to have anything as a mandatory, but look, I practice law like you do, and I think all the other commissioners, even those that don't practice law, they understand the practicalities of life. And I don't like mandatory rules that mandate what we have to do under a certain given situation, but certainly if the commission is so inclined to keep the rule as it currently stands and reject this mandatory rule, I'm sure that the courtesies you've seen in the past would be continued.
I appreciate the opportunity to comment.
Thank you, sir. And I appreciate your comments, and I think it actually, the way you did it actually made the process more expedited than the slow process I had in mind, so.
Thank you all.
Unless Ms. Guerin wants to have her shot to speak right now, let Mr. Viette come up, because I think he has some shorter comments than she does.
Mine was on 16, we still on 13?
Were your comments on all 13 and 16?
Yes, sir.
Okay, let's just take comments on whatever you want to make comments on, either 13 or 16.
Leon Bucky Viette, 114 Magnolia Street, Lake Arthur, Louisiana. I just have a question about 16. I know this commission has been, I think, established in 1994, if I'm correct.
1991.
91, okay. I have a question for 16.4 on formal charges. John Q. Public.
Just give us one section.
Okay, let me get to it.
Page 50.
50. Back there. Okay, Mr. Viette.
Okay, under formal charges, 16.4, B4, I believe it says to identify the provision of the State Police Commission article and/or which State Police Commission rule was violated. John Q. Public, to begin with, the individuals are leery to file charges against state police to begin with. This puts a further burden on them that how are they to know the provisions that the officer or officers have violated? And my question is, should that be eliminated? And I would ask, how many public complaints has this commission received since 1991? And how many public investigations have they done because of that?
I don't have, off the top of my head, a count. Oh, you have,
Maybe one or two.
okay.
I'm not sure. Don't hold me to that, please.
As you found on our website, the rules of the State Police Commission are all contained on the website and for the general public. And I believe if charges are being brought for a request for investigation, then the person bringing those charges would have some general idea of what was violated in policy, but specifically rule.
Well, let's take a look at it. Let's take a look at it. I mean, I understand the concern that he's raising. We'll take a look at that.
Okay,
And
that's all I asked. It was just a question because I was thinking maybe something along the line, if somebody called the director and wanted to file a complaint, and they gave him basic idea of what the complaint is going to be, maybe the burden should be on the director to advise them of what provisions may have been violated.
that may be one way to address it. Maybe another way would be looking at how we might want to, I don't want to speak, I'm speaking for the commission, but there's different ways we might address that issue. But that's one suggestion, yes.
Thank you, sir.
All right. Well, I appreciate the comment. It is something we need to look at, I believe. All right, Ms. Garrett. I would say we save the best for last, but then we make Floyd feel bad, so we won't say that.
My name is Michelle Gerard, and I'm an attorney for Louisiana State Police. I want to thank Jason for his work on this, and for also, I know you reviewed all the comments and you took them to heart. And for me, the one that Mr. Falcon commented on about email and facsimile and all, to get in the electronic age, I requested that we have an opt-in provision like civil service does to receive it. I do check email daily. And what prompted that, Mr. Falcon should know, is we recently had a case where we took an action after the matter was within the commission's jurisdiction, but we didn't know that an appeal had been filed until 12 days after it was filed. So that created a problem for us where with email, if I had gotten it sooner, and the matter's been resolved, but timely notification is important, and the email gives us that opportunity, so I appreciate that. It's going to be a great help for us.
But it's an opt-in situation.
Yeah,
Correct.
I thought Michelle's comment related to notice of a hearing date.
It could be any notice, any communications.
But
with
it's
the
an
opt-in.
opt-in, so if
I
you
mean,
don't,
that's what
if
my
you don't want
comment
it, you
was
don't.
directed for. So I appreciate that. On the revisions after comment, I am on page 7. It goes to rule 13.3, delay for making an appeal. I see with the proposed revisions to section B, it actually extends the delay for making an appeal. And I would say that that's unnecessary. Civil service doesn't allow this because civil service is of the position our office is always open, because with your proposed additional changes, if you can file by fax, if you can file by email, their office is always open. And 30 days is a lot easier to follow than, was this a holiday, was the office open, was it closed? If you can file by email or fax, there should be no reason you can't file it by the 30th day.
I appreciate the comment on it. One of the considerations that I had, I won't speak for the rest of the commission, is that if the 30th day falls on Christmas, I don't care that you can get it here by fax. I think it would be unreasonable for an attorney to be expected to file it on Christmas Day.
That's the 30th day.
Well, I understand.
The other comment that I have is on page 13, and it deals with summary disposition, specifically the proposed revisions to G.
On page 13?
Yes.
Okay.
In G, it now talks about documents produced in response to subpoena. And we just had a discussion about pretrial discovery and all. If there's no pretrial discovery, how would you be able to issue a subpoena for documents to include in a motion for summary disposition. And I see that we took out the part about written stipulations and admissions, and the question that I posed was, what does this commission consider an admission? And if it was strictly admissions of fact like you get when you have pretrial discovery in civil matters, we can't have that, but I'm gonna tell you there's a lot of cases. As Mr. Falcon pointed out, we do get written statements from employees. We do compel them to come in and participate in an interview under oath, and a lot of admissions get made during the investigative process, and my question is, can we include those as admissions? I went back and researched a prior case before the commission where a motion for summary disposition was filed, and attached to that motion was a transcript of the recorded interview of the employee that was taken under oath, where the employee admitted to the conduct, and that made it really nice and quick for the commission to review and say, based on the employee's admissions, the summary disposition was granted, because there really weren't any facts in dispute, and the conduct for which the employee was terminated was admitted to. So that's the question I have, if we can use those types of documents, if the agency files a motion for summary disposition, essentially what it shows is these facts aren't in dispute. We don't have any other way to get admissions, and stipulations are hard to come by these days in these appeals. So that's my comment with regards to that. I think there's a lot of cases where we could wrap things up kind of quickly when the employee admits to the conduct, when they're under oath or in a criminal investigation, after they're advised of their Miranda warnings and they admit to the conduct. Why shouldn't that be allowed to be used in a motion for summary disposition?
We'll take a look at it. But we will also recognize that summary disposition is a very limited process, whereby if there are disputes of fact, despite what someone might say on one day, there might be another statement on another day. Obviously, someone who is not consistent in their statements has credibility issues, but we can't resolve credibility in a summary disposition.
I think that Michelle's comments highlight the fact that I said she can call those people, the IA can call those people in and force them to give a statement, and I can't, you see, in trying to defeat or something.
You know, my mom once told me, Mr. Falcon, shut up when you're ahead.
Yeah.
My next comment's on page 45 with regards to 13.28. It deals with mediation. In my years of doing this, we've never had a formal mediation that I'm aware of, but I'm just concerned about the vagueness of "or another person." There's no requirement that another person who would have mediation has any kind of training or experience in mediation. I just think that leaves it just a little broad, that another person could conduct mediation. We would like to.
What page are you on?
Page 45.
45, I'm sorry. I misheard you. Let me get there, please.
I'm glad you changed it to mediation from medication too.
Sometimes medication is good. So where do you see "or other person"?
B.
B. Obviously, since a mediation is a voluntary, there's nothing in here that I'm aware of that would require the mediation. The parties would have to agree to the mediation, and the terms of the mediation would include who the mediator would be. So I don't think that's going to be a problem.
It just gives leeway beyond the commission.
Right, so that could be one of the many well-trained mediators we have available. Yeah, but y'all would have to agree, so that's not going to be a problem.
And that's all the
Who
comments I
pays
have.
for that was one of the questions I had.
That would be something the parties would have to agree about.
Thank you.
Does anyone else have any comments on the proposal? And we will officially promulgate these by way of a circular, a general circular, well in advance of the meeting at which we're going to vote on it, and no one's rights, I know I said this already, I'm just repeating it, no one's rights to make comments at the formal public hearing are prejudiced by their comments here or their failure to comment here. Right. Would any of the commissioners have any comments at this point? So we'll move on to the next agenda item. It's Director's Report.
Mr. Chairman, the only item I have for the Director's Report is the expenditure detail, which is listed behind tab 3.
We're not going to bore everybody.
And then I would say one extra item is to remember everyone's ethics training is due by the end of the year. Yes.
So that's directed to us.
And myself and my staff.
Oh, okay. Now, we have an opportunity to address the commission for items which are not on the agenda, and we had two requests, one from Mr. Robert Burns.
Mine's provisional. I'm gonna let him, if it's okay to let him go first.
Sure. I was going to go in alphabetical order, but that's fine.
I go by Bucky.
Well, there you go, B-U-C.
Okay, you win.
John Bucky B. at 114 Magnolia Street, Lake Arthur, Louisiana. As this commission should be well aware by now, I'm very concerned about the politicalization of the Louisiana State Police. I think they have become from apolitical to a political organization. I was concerned that the state police filed a suit against the circular that you had passed, filed a suit back in August, and I believe the commission was served August the 28th with this suit. And we've been monitoring to see if there's been any activity. We found that there was an answer where y'all have asked, or your attorney has asked for a dilatory exemption, and that's the status of it right now. Political season is approaching us, we know, and my question is, does the commission stand by its circular? Will it stand by its circular? Will it take any action if the association chooses to endorse a candidate or make political donations? I'm concerned about the status of the suit and the circular.
The only response that I can give you to that, I can't give you a legal opinion response to it, is that our circular is in effect until ordered otherwise. And we generally don't issue circulars without intending to abide by it.
Thank you very much.
Ms. Burns?
I'll just follow up briefly because I'm going to dovetail on what he said. I did take an opportunity to read over the dilatory exception. Some of you may be aware that I initiated litigation against the Auctioneers Licensing Board on 7 or 8 occasions. So, in fact, my attorney said, Robert, if we were in the days of Abe Lincoln, I could let you apprentice this and join my firm, but I always seem to either get Judge Caldwell, Judge Fields, or Judge Hernandez. 3 times Caldwell, 2 times Fields, 2 times Hernandez. I know that Judge Caldwell is the one who was drawn in this case. I know Judge Caldwell has quite a reputation that every I has to be dotted, every T's got to be crossed, or he's not signing it. And the one thing, and I'm not an attorney, but I will admit I spend a lot of time in courtrooms, and I really do love, it's a fascination I have. I do love to go and sit and watch attorneys argue. I know that's a little bit of an odd thing for somebody who's not an attorney, but I enjoy it. I did notice on the dilatory exception that there was no order page to set a contradictory hearing and then provide what would be Mr. Falcon. I would have expected to have an 8-day period prior to the hearing being established to propose his memorandum in opposition. So I hope that that that's going to transpire, because I'm kind of looking forward to seeing that do, but perhaps it's not required. I just know, I was hit with a dilatory exception. I know this one is on prematurity. My dilatory exception that I got hit with by Mr. Bankston, he said that I was not concise enough in my pleadings to conform with, I believe it was Code Civil Procedure 954, but it's all been a while now. But I fixed it, you know, and so we did proceed on forward. But I guess I'm hoping, and maybe we can get clarification, I'm looking forward to, I hope, not getting cheated out of getting together a court hearing to hear a hearing on the dilatory exception. Was there just not an order page done, or is it not going to need to be a contradictory hearing?
You're right that you have to have an order page in order to have a hearing, but the determination has not yet been made about if it will be on that or if it'll be on a broader issue, and there'll be some discussion with opposing counsel before that decision is made.
Okay.
It's not uncommon in litigation when exceptions are filed along with the answer to defer asking for a hearing at that time until more progress is made. It's not an uncommon practice.
Okay, well, it was also my understanding during my little apprenticeship that once you file an answer, you give up some of the other maneuvers. Is that?
We haven't waived anything with our answer that that's some of that is older law as well, and there's some changes, but
You got his line?
we're in good shape.
Sounds good. I'm hoping I get to see the little courtroom at some point, but if I don't, I don't.
Alrighty, all of the requests for public comment on any other business by any commissioners. Without that, I'll entertain a motion to adjourn.